Hey, welcome back. I was on a video call with my parents in Dhaka last night, and my dad, ever the civil servant, was telling me about a new traffic law that's just been passed. And he said, with this mix of pride and frustration, the law is the law. It's not a suggestion. That phrase stuck with me, because here in America, I've been watching a different story unfold. One where, for a growing number of public officials, the law is being treated as a suggestion, one they feel increasingly comfortable refusing to follow. I'm Ibnul J. Farabi, and this is The Unraveling Thread, a production of Light, Not Studios. Today, we're pulling on a thread that's straining the very fabric of our civic compact. Episode 35, The Opt-Out, inside the movement of public officials refusing to enforce law. Let's start with a simple, almost uncomfortable question. What happens when the people we elect or appoint to uphold the law simply decide not to? We're not talking about corruption in the shadows. We're talking about a public, principled, and politically charged refusal. It's called prosecutorial discretion, or administrative non-enforcement, and it's moved from a quiet bureaucratic tool to a loud political manifesto. From district attorneys who announce they will not prosecute certain low-level crimes, to sheriffs who publicly defy state gun laws, to governors who instruct their agencies not to enforce federal regulations. This is the opt-out movement, and it's forcing us to ask, is this a necessary check on unjust systems or a dangerous step toward the rule of men, not laws? To understand it, we have to look at the two distinct philosophies driving it. On one side, you have what I'll call the moral disobedience model. This gained huge traction after the police killings of 2020. Progressive prosecutors in cities like Philadelphia, San Francisco, and Boston were elected on platforms promising to stop prosecuting things like turnstile jumping, disorderly conduct, or drug possession for personal use. The argument is powerful that aggressively enforcing these so-called quality of life laws perpetuates systemic racism, criminalizes poverty, and fills prisons without making communities safer. The law, they argue, is not an impartial blueprint. It's a historical artifact of bias. And their moral duty, as elected officials, is to stop the harm. They see themselves as a circuit breaker in an unjust system. Now, flip the political spectrum, and you see a mirror image, which I'd call the sovereign resistance model. This is most visible in the immigration and gun policy battles. For years, we've seen so-called sanctuary cities limit cooperation with federal immigration enforcement. But the response has crystallized too. States passing laws that directly contradict federal mandates, and county sheriffs vowing to be the last line of defense. A sheriff in rural Oregon might declare he won't enforce a new state gun control measure, arguing it infringes on a constitutional right. A governor might sue to stop a federal vaccine mandate, and then issue an order telling state agencies not to comply with it. Their reasoning? They are defending a higher sovereignty, state, county, or individual rights, against an overreaching, illegitimate federal power. What's fascinating is that both sides use the same foundational language, justice, rights, protection, but they are speaking entirely different constitutional dialects. One dialect is focused on equitable outcomes, on correcting historical wrongs baked into the legal code itself. The other is focused on jurisdictional process, on defending spheres of authority from encroachment. They are both, in their own minds, opting out to protect their communities. But the communities they envision and the threats they see are diametrically opposed. This is where my engineer's brain starts to worry about systemic failure. Because a system of laws relies on a chain of trust and predictable application. It's like code. If one function consistently refuses to execute a command, the whole program can glitch, or worse, crash. When a DA opts out, police on the street can feel demoralized, asking, why make the arrest at all? It creates a feedback loop of frustration. When a sheriff opts out, it creates a patchwork map of enforcement where your rights or responsibilities literally change depending on the county line you cross. This doesn't feel like justice. It feels like geographic luck. And when state leaders opt out of federal rules, we edge closer to a constitutional crisis, a slow-motion secession of policy. The opt-out, in its brazen publicity, normalizes the idea that law is optional based on personal conscience or political affiliation. And that's a precedent that can be weaponized by any side, in any direction. I think about my father's conviction in Bangladesh, a country with its own deep struggles with governance. For him, the sanctity of the rule of law, however imperfect, is the only thing that stands between society and chaos. That perspective, born from a different context, haunts me when I look at this trend here. Because the American experiment was designed with dissent and federalism in mind, with mechanisms for change. The ballot box, the legislature, the courts. The opt-out movement, in some ways, represents a loss of faith in those very mechanisms. It's a shortcut, a unilateral veto. And while a shortcut can sometimes get you around an immovable obstacle, it also means you're no longer on the main road, with everyone else following the shared map. So where does this leave us, as citizens listening to this unraveling? I don't have a simple answer, because I can see the moral urgency on both sides of the debate. The need to stop mass incarceration is as real to me as the need for a coherent national policy. But I keep coming back to a distinction between challenging a law and nullifying it. Challenging a law means using your office to fight it in court, to lobby the legislature to change it, to use the pulpit to persuade the public. Nullifying it means you, as an individual official, have decided to become the judge, jury, and executioner of that law's fate. That's a profound concentration of power. And history tells us to be wary of any concentration of power, even when it's wielded with the best of intentions. The opt-out movement is a symptom of a deeper disease, a polarized polity that has stopped believing it can win the argument, so it resorts to disabling the system. It's a dangerous game of chicken, each side waiting for the other to blink, while public trust in the system itself evaporates. My takeaway is this: we must be vigilant observers of this space. We have to ask not just, do I agree with this official's goal, but do I agree with this method? Because the method, this tool of public refusal, will be inherited by the next administration and the next, with goals you may find abhorrent. The unraveling thread of consistent legal application can snag on any ideology. Our job is to hold on to the principle that in a republic, the law, however flawed, is changed through collective action, not individual negation. The hard, slow, frustrating work of democracy is still the only sustainable path. Thank you for listening. If this conversation resonated with you, please share this episode with someone who thinks deeply about these threads that bind us. For more from me, Ibnul J. Farabi, and the entire team, subscribe to The Unraveling Thread wherever you get your podcasts. This has been a production of Light Knot Studios. You can find our full archive and learn more about our work at lightknotstudios.com. Until next time, take care.